Welcome. I sense a little bit of doubt from Bruce as to how much fun this is going to be today. I don't understand really what he's talking about, but so I'm a lawyer with a law firm called Miller Johnson. Is anybody familiar with Miller Johnson? Yeah, yay, right. Been with Miller Johnson for over 20 years now, and I am chair of our firm's FMLA ADA Solutions Practice Group, which means I get to spend, more time than ever talking to folks like you about medical issues in the workplace, FMLA, ADA, et cetera. And for those of you who are doing that in your workplaces, I think you would agree that we're talking about those issues, I think, now more than we ever did before, working through reasonable accommodation, FMLA, and excitingly enough, what's new here in Michigan, guys? Paid medical leave, right? So I've had an awesome winter helping, I think at last count, 123 employers get their PTO policies, vacation policies, sick time policies in compliance with the new Michigan Paid Medical Leave Act, right? In addition, I do other types of general employment law too. I spend about half my time talking to HR folks on the phone, trying to help them stay out of trouble, get them on the right track, and then about half my time in the courtroom litigating too. So the second half is pretty fun because I get to bring in lots of fun stories about the stupid things that other employers have done, right, that have gotten them sued, and then in a format like this, we can all learn from that, okay? The first and probably the most important question is, how do I know if I really have to care about the FMLA? Does it apply to my organization? Okay? The answer to that question is FMLA applies if we have 50 or more employees. I should have warned you ahead of time. There's no simple answers with the FMLA, right? Okay, so already the question is what? How many people do we have to employ for the FMLA to apply to us? You would think the answer would be what? A number. Of course, it's not just a number. It is if you employ 50 or more people for 20 or more calendar work weeks in the current or preceding calendar year, the FMLA applies to you. Okay. Now, if you are an organization with more than one location, for the purposes of the answer to this question, we count all of our locations together. Okay? So we add them all up. Schools, by the way, are covered no matter what. So if any of you are from schools, that answer is easy. All right, so we count somebody if they are on our payroll, guys, okay? That's the rule. So if we have people who come in and out of employment, but we keep them on the payroll all year, we have to count them for the purposes of determining whether or not our entity is covered by the FMLA, okay? Other employees we have to count those whom we jointly employ through temp agencies, right? So any temps count toward the 50. Integrated employers, that's referring to two businesses that are related to each other enough so that we have to pool all of our employees for the purposes of coverage. And independent contractors, we might have to count them too. That's a pretty separate, detailed legal analysis, okay? With regard to those last three, you're going to care most about that if you're close to 50, but you seem to think we're not there yet, right? That's when I usually ask a client, well, do you have any temps, right? Do you have any independent contractors, et cetera? And if so, then we may have to count them too. I mentioned the single enterprise or integrated employer test. This is the rule that applies to two entities that are legally separate entities, okay, but they are so interrelated that the FMLA would say those are actually one single employer. I don't care if you have two separate tax IDs, two separate names, etc. If there's common management, common ownership, etc., the FMLA would say those are really the same entity for the purposes of counting employees. Right? Her question was, I've heard about this 75-mile radius thing. What does that mean then? Okay, and the answer is, it does not apply to that initial question as to whether you have to comply with the FMLA leave, but it's relevant to this next question, which is, who gets it? Okay, so your organization could be covered by the FMLA, the entire thing, which means we have to have postings, for example, right? But you may have employees that work at a location that aren't eligible to take FMLA leave. Okay, and that is, to be eligible to take FMLA leave, every employee has to meet 3 requirements. The first one is they have to have worked for you for a total of 12 months. We're going to talk about what that means. The second one is they have to have worked at least 1,250 hours in the 12 months immediately before their leave starts. And then the third one is they have to work at a location that has 50 or more employees within a 75-mile radius. Okay, so I've got lots of clients that are covered by the FMLA, but some locations have employees that are eligible, and some locations have employees who aren't, because there's only 7 folks there and they don't have another location within 75 miles, okay? That creates a fun discussion about what we say in the handbook about FMLA, right? Okay. Okay, all of these things are calculated as when the leave begins, when the leave commences. And that's important to remember. They're not calculated when somebody requests the leave or tells you they need it. Let's take an example. Employee comes to you and says, I'm pregnant, right? I'm not going to need to take FMLA leave, I don't think, during my pregnancy, but I am going to be taking time off, of course, after the birth of my child, right? My birth, my estimated date of delivery, is 6 months from now, okay? For the purposes of eligibility, we don't count hours when that employee comes and talks to you. We have to count the hours when that employee begins the leave, the date of which we don't know for sure, right? Okay, so again, we've got to go with the flow with the FMLA, right? So in a situation like that, we would tell the employee, yes, we think you're going to be eligible, et cetera, but you need to understand here are the criteria you're going to have to meet. Okay, every once in a while I get an employee for whom she's so close to the 1,250-hour requirement, we really don't know until that day whether she's going to be eligible or not. And then we sort of tweak our notice system, et cetera, to account for that. So for the purposes of counting the 12 months, it's actually a total of 12 months within the last 7 years. So if an employee has come and gone, worked for you 3 years ago, and has now just been hired back, we need to give them, quote unquote, credit for the time they worked for the purposes of that total of 12 months. That's only for the 12 months. Okay? Still got everybody? Good. Okay. And by the way, if an employee is off on military leave, that 7 years can even be extended longer than that too. Okay? For the purposes of counting the 1,250 hours, we count only time actually worked. Okay, I get this question all the time. We don't have to count what? Vacations, holidays, what else? How about FMLA they took? No, right? It is quite literally only time that they are actually performing work for you, okay? Even if they got paid through some sort of paid leave, that's okay. And for both of those things, we have to count their time that they spent with us through a temp agency. Okay, so if you are an employer that uses a temp to hire model, right, you're going to have folks coming in your door already partway or entirely eligible for FMLA leave. Because all of that time they spent working through you through the temp agency counts toward both of these requirements. You can hear the question, I think, was for the purposes of counting the 1,250 hours, do we count weekends? Is that the question? Right. Okay, so the first thing I'll point out is we're not counting days, we're counting hours. Right? It's 1,250 hours, and it doesn't matter on what day they worked. You would have to, so the question is, if I work for a trucking company and it's hard for me to track how many hours exactly they're working, what I would say is the best thing we can do then is, yeah, take it off their log. And for you guys, it's going to be all hours that are compensable under the Fair Labor Standards Act. So the question is, if an employee becomes eligible for FMLA leave, does that mean they are forever eligible? And the answer, of course, is no, of course not, right? My job wouldn't be very fun if that were the case, right? Every time somebody requests a new FMLA leave, we determine whether they're eligible for that leave. Okay? So I may be eligible to take FMLA leave for a surgery this year. And let's say I take 12 weeks of FMLA leave and then that gets extended, so I'm off 6 months. Next year, if I have a different need for FMLA, I might not be eligible because I won't have worked 1,250 hours. Employees can become eligible for FMLA leave during a leave of absence. Okay, now this is a rule that changed when we had our most recent change to the FMLA regulations, and I need to stop calling them new because they're actually from 2009, and I'm really dating myself when I keep calling them new, but they are the newest, okay? With the latest round of regs, the Department of Labor said somebody can actually become eligible while they are off work. Okay, so let's take the example of me having surgery this year. Let's say I need to go off on for surgery on June 1st. I've met my hour requirement. I've already worked 1,250 hours. But I've only worked for Miller Johnson for 11 months at that point. Okay? I am not eligible for FMLA leave when I begin my leave. However, if my employer gives me the time off, I am going to become eligible a month into it. What's your name? Justin makes a great point. He says, but let's be clear, if I'm not eligible because I didn't meet the hours worked requirement, I couldn't possibly become eligible during my leave. And yes, exactly, because I won't work more hours during my leave. That's sort of the definition of a leave, right? Unless it's an intermittent leave, which we'll get to. Okay, so what that means for me then is I'm going to be off because my employer's a nice employer and has said, Sarah, you need surgery. We like you. You're a good employee, so we'll give you the month off, even though you're not eligible for FMLA yet, right? I'm going to become eligible a month in, at which point my employer is supposed to send me the FMLA forms and tell me that. Okay? And that also means the real impact of that is what? I could take how many weeks off? Right? 12 plus the original 4 or so in that first month that I got, quote unquote, sort of for free. So the question really was, what if I had a mean employer who wanted to say, we are not going to give you time off for your surgery, Sarah, and we're just going to go ahead and fire you if if that's what you need, right? Can we do that? Okay. I know the HR and all you guys are sort of cringing, like, I don't know, it feels like we definitely shouldn't, but I'm not quite sure why, right? There would be a couple of concerns for that. Number one, the Americans with Disabilities Act applies no matter how long somebody's worked for us, right? And you guys may have heard the ADA says that if an employee needs time off because of a disability, then we may have to give that to them as a reasonable accommodation under the ADA. We are going to talk about that a little later too. So that would be my first concern. What's going on? What's the condition, et cetera, right? And then also we would want to make sure we're okay with discrimination issues. So for example, if we have given employees leaves of absence for medical reasons, and a woman says, I need time off because of pregnancy, we'd want to be real careful there, right? Because pregnancy is a protected class, and we wouldn't want to discriminate or treat an employee who's pregnant less favorably than we've treated others. So my long answer is, I don't know, you got to be careful, and you might want to call a lawyer to talk through those issues. If you don't, yeah, so the question is, for the counting of the 50, right? If we have to count everyone on our payroll, does that mean we better get our seasonal folks off the payroll? And the answer is absolutely yes. So if the Department of Labor said, I need a copy of your payroll for the last two years so that we can count heads and see if you had 50 or more for 20 or more calendar work weeks, we could give that to them and we would not. Okay? Makes sense. That will help you also with Michigan Paid Medical Leave Act and how that applies to seasonal employees too, just FYI. Okay, right, so the question is, if it's not FMLA and they say to us, for example, I'm having surgery, what do they have to tell us? And my answer to that is we can require medical information from them to confirm that as part of the reasonable ADA accommodation process. And in fact, we very much want to, because we need to know lots of things, like what's going on, is there any or are there accommodations we could make so you could work? Do you have an estimated date of return? If so, what is it, et cetera? And I've got a form that I typically, a non-FMLA medical form that I typically use for those types of leaves. Just anecdotally, with regard to non-FMLA leaves, you guys want to have a system in place that is like the one you're using for FMLA leaves, okay? Otherwise, you get down a rabbit hole of this person's been off for X long and they just keep bringing me in doctor's notes saying when their next appointment is, and I really don't know what to do about it or how to manage it. The question is, so how much time do people get, right? We talked about are we covered, we talked about who gets it. The next question is, how much time do they get? And the answer is usually 12 weeks per year. There are a couple of unique military leaves, military family leaves, for which employees get 26 weeks. Not going to spend a lot of time talking about that because I don't see that coming up a whole lot in West Michigan, I'll be honest. Okay? The type of year that we use is our choice, okay? And by year, I mean, remember we get 12 weeks per year. We get to decide how to define that 12-month period. It can be a rolling backward year, it can be a rolling forward year, it can be a calendar year, it can be a fiscal year. The vast majority of employers that I work with tend to use that rolling backward year. Seeing nods. Is that what most of you guys use? Explain one thing. Most employers use this rolling backward leave year because it avoids the result of an employee taking 12 weeks of FMLA leave at the end of one calendar year and then having the ability to piggyback on that and take 12 more weeks at the beginning of the next calendar year. Does that make sense? I quite frankly, now that non-FMLA leave as a reasonable accommodation under the ADA is becoming more prevalent and allowing employees to extend leaves after FMLA has expired anyway, just so you know, I tend to question whether it really matters if you use a calendar year or not. That's just an aside. So that's the benefit of not using a calendar year. The cost of not using a calendar year or using a rolling backward year is it's an administrative nightmare, right? I shouldn't say a nightmare. For those who have lots of employees taking intermittent FMLA leave, it's a pain in the neck, okay? So the idea of the rolling backward year is that an employee always has a total of 12 weeks to take, starting with today and looking backward 12 months. Which means then that if you want to know how much FMLA leave I have to take today, you have to subtract all of the FMLA leave that I've taken in the last 12 months from my total bank of 12 weeks. Have I lost anyone? No? I'm getting nods, okay? So that will always depend on how much time has already been used. Now, for employees who are taking intermittent leave, intermittent meaning not continuous leave in one chunk, small bits of time in days or parts of days or 15 minutes, right? Functionally, what you discover as you administer it is that they actually earn it back every day based on what they took 12 months ago, right? So if I took 6 hours of FMLA leave a year ago, was today, June 19th, 2018, 6 more hours is going to land in my FMLA bank today, June 11th, 2019. The law itself and the regs talk about FMLA in terms of weeks. You guys, HR folks, are way smarter than Congress or the Department of Labor. And you guys all figured out really quickly that unless an employee is actually using FMLA in week-long increments, that weeks is unworkable. Right? The Department of Labor says HR folks are supposed to apply it in fractions of weeks. Like, for example, if an employee is supposed to miss, or an employee works 5 days a week and they miss 1 day, that would be 1/5 of a week, and I guess you guys are supposed to keep spreadsheets of all those fractions and then know how to add them together. I'm out at that point. That's why I went to law school. I'm not adding fractions and finding common denominators and things like that, right? So what HR folks quickly figured out is, well, that's okay. We'll just convert weeks to what? Hours. Okay? And that's why you often hear you have X number of hours of FMLA. And that is perfectly fine. It's perfectly fine so long as you do it right. Okay? In other words, what you don't want to do is assume everyone gets 480 hours. Why did I pick 480? Because that's 12 times what? 40, right? For an employee whose regular schedule is 40 hours a week, terrific. They get 480 hours. For an employee whose regular schedule is 60 hours a week, right? They get more than that. For an employee whose regular schedule is 30 hours a week, their FMLA entitlement bank is going to be lower than that, right? For a salaried exempt employee for whom we don't know how many hours a week they work, right? We throw our hands in the air and say, I don't know, I guess I'll just let them take whatever FMLA they want. If you have employees, variable hour employees, who don't have a set or normal schedule from 1 week to the next, right? That can apply to part-time variable hour employees. That can also apply to employees who work a lot of overtime, okay? We are supposed to calculate their banks by taking the average hours scheduled It's important, not worked, scheduled over the 12 months, right, commencing on when their leave starts. So you look back 12 months and take their average hours schedule. Okay, now don't forget, when we're looking at how much somebody worked, we're looking at it for two reasons, right? The first one is, has she worked enough hours to be eligible? And when we're calculating whether somebody's worked 1,250 hours to be eligible, that we use hours worked for that. I want to be clear, right? So if you had said to me she only worked 20 hours a week, I would have said, well, time out. I don't know if she's eligible at all, right? Why? It doesn't matter how much she gets. First, she has to meet the eligibility requirements. Once somebody gets through the threshold of being eligible, then we talk about how much time do they get. And yes, if they have that variable schedule, it's the average hours scheduled in the 12 months immediately preceding their FMLA. Honestly, first of all, from a practical standpoint, don't forget, if somebody's off continuously, we can always use weeks, right? So if your person said, I need surgery, I need FMLA, what I would say is, well, just count how many weeks that person is off and get out of the hour loop, right? If they're off continuously. If that person needs intermittent leave and they have no real schedule and they can show up when they want, I guess I don't really understand why they would need intermittent FMLA, right? So the next question is, I know if we're covered, I know who can take it, I know how much they have, but when can people actually use this stuff, right? For what reasons can they take FMLA, okay? We're going to talk mostly about the definition of a serious health condition, but before that, I want to give you the 10,000-foot view, okay? So employees can take FMLA leave for their own serious health condition, to care for a parent, spouse, or child with a serious health condition, right? That's why we're going to talk about what a serious health condition is. And to bond with a newly born or newly adopted child. For that reason, the newly born or newly adopted child, nobody has to have a serious health condition. There just has to be a new child, okay? And then lastly, employees can take FMLA leave for certain qualifying exigencies. I apologize for the use of that word, but blame the Department of Labor, that result from a family member being called into active duty in the military, okay? We don't see that a whole lot in West Michigan either, so we're not going to spend a whole lot of time talking about it. Okay? So we tend to spend, we meaning me, HR folks who are dealing with FMLA situations, tend to spend most of our time in the world of, does this person have a serious health condition, or does their family member have a serious health condition such that the FMLA applies? Okay? To know whether they do or don't, they complete these things called medical certification forms, right? Okay, and I'm going to talk a little bit about how we give that to them and the timing and all that stuff. That's coming. But that's the form that asks the questions that provide us the answers that we need in order to figure out whether they fall into any of these categories, okay? All right, and those are the forms in front of you. Okay, so generally speaking, serious health conditions fall into two buckets. The first one is inpatient. That means somebody has been admitted to a hospital or hospice facility overnight. Okay, the second bucket is continuing treatment. Okay, we're going to talk about both of those. Again, first is inpatient. That's an overnight stay. That is not waiting in the ER to be seen overnight. That is actually being admitted in the hospital overnight. So an employee calls and says, I can't come to work today. My husband's been admitted to the hospital. A big red FMLA flag should go off in our heads, right? Automatically. Questions on inpatient? Good, because you'll have lots of questions on the next one. Okay? If it's not inpatient, then an employee has to satisfy one of the types of continuing treatment under the FMLA. And the Department of Labor has defined those in a number of different fashions, right? There's a number of different categories of what I call continuing treatment. The overlying theme, though, is really important for you to remember, big picture, right? And that is the word treatment, right? All of these types of conditions under the FMLA, for the most part, that person has to be getting treated for it. Okay? So the first type of continuing treatment applies to what I call sort of the seasonal illnesses mostly. These are the what, right? I get a big spike in these phone calls between like February or between November and March, right? When people have pneumonia, strep throat, sinus infections, etc. Okay? And this is the Department of Labor's way of deciphering out what condition is just your common cold or flu, such that the FMLA doesn't apply, and which ones are serious enough that that employee should get the benefit of the FMLA. Okay? So here's the line that the Department of Labor has drawn. If an employee is incapacitated for more than three, right, which is not just 3, but more than 3 consecutive calendar days. So let's think about that for a minute first, right, guys? A couple of key words: more, consecutive, and calendar. Calendar days versus what days? Work days, right? So an employee could get to more than 3 consecutive calendar days by calling in Friday and Monday. You've only had 2 call-ins, yet they've been incapacitated potentially for more than 3 consecutive calendar days, right? Okay. But it's not enough just to be incapacitated, remember, because I said treatment's important. They have to also get treated, meaning seen in person, not talk to somebody on the phone, not gone on WebMD, seen in person by a healthcare provider within 7 days of when they first got sick, and they either got some sort of prescription or regimen of continuing treatment from that first appointment, or their provider is a real stickler and said, what at first? I think it's a virus, go home, drink water, blah, 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 blah. Didn't give them anything, right? And then the person goes back within 30 days and gets seen a second time by a healthcare provider. Okay, so sort of think that through with the illnesses, right? Employee calling in saying, I think I have a sinus infection. I have an appointment with my doctor today. I'm going to go be seen, right? If they've been incapacitated for more than 3 days, they're almost there, right? If they can get a prescription, then it's FMLA. If their provider says, it's just a virus, I don't think you have a sinus infection, and sends them home, it's not FMLA yet. Okay? Now, does anybody see the problem with the 30-day thing? When do you want to know whether the FMLA applies? Like now, right? Right? So it doesn't apply yet. They haven't satisfied the requirements. But if they go back a second time within 30 days, then the FMLA is going to apply to all of those absences for that serious health condition. Well, let's talk about it. The question is, what if we fire them in the middle of their 30 days? Which means we would know they were incapacitated for more than 3 days, right? We would know they went to a provider once within 7 days, and we made a decision to count those absences under the attendance policy and end their employment. okay? They could have an argument then. Then all they have to do is go to the effing doctor and sue you. In all honesty, I mean, I would be careful with doing that. So remember, what it says is you have to be incapacitated for more than 3 days, right? The definition of incapacitated is unable to perform one or more of their essential job functions. Right? So it depends on their job. If they're contagious and they can't come to work, then the FMLA would apply because they're incapacitated, right? Right? If they work from home and you don't really care if they're contagious or not and they can do their job as far as you're concerned, that might be a different analysis. All right, next type of continuing treatment is easy peasy pregnancy. Okay? I just got this question actually from a client yesterday, right? So we've been applying FMLA leave after a woman gives birth, but I guess we haven't been applying it during her pregnancy when she's missed work for prenatal visits. Are we supposed to be doing that? Yes. Yes. Now, if you're not and you're letting her miss work without counting it against the 12 weeks and she's not getting disciplined for it under the attendance policy, you've done nothing unlawful. You've just given that employee more, because you've given her the time off work without counting it against her FMLA bank. Does that make sense? Okay, so pregnancy by itself is a serious health condition. That means any employee who needs to miss work due to pregnancy, including treatment, prenatal visits are treatment, right? Falls under the FMLA. Equally, an employee can take FMLA leave to care for a spouse, a parent, that would be weird, or a child, right, who is pregnant too, and attend those prenatal visits. You have an employee who says, my daughter is pregnant, I would like to take FMLA leave to accompany her to her doctor's visits and to care for her after the birth of her child, assuming she's under the age of 18. So, yeah, the question is, well, what if you just want to take a vacation day? So the first thing I'll say with that is don't forget FMLA and paid time, including vacation time, are not necessarily an or. Okay? An employee using FMLA leave actually has the right to also supplement unpaid FMLA with any paid time they have available, and we can make them do it, right? So in your example, why not both, right? Why not have it offer the FMLA, and if he wants to take, quote unquote, a vacation day, that's cool, he can still get paid for it, but it's also going to count as FMLA. And when I say count as FMLA, don't forget, guys, that's a mutual benefit. They get the protection of the FMLA, and we also get to count that time out of their total 12-week entitlement. Anyway. Right, so we're getting a little bit into the notice requirements, which I'm going to talk more about, but I'll just give an overview, and that is, if we know somebody is missing work for something that falls under the FMLA, meaning these things I'm talking about now, then we are obligated to give them certain notice forms to offer them the opportunity to use FMLA. If they don't return them and dig in their heels, then we can decide what to do about that. Okay, generally speaking, a parent can only take FMLA leave to care for a child who is under the age of 18. There's exceptions to that. We're going to talk about that too, hopefully, right? Okay, so the answer to your question is a parent can take FMLA leave to care for a pregnant child under the age of 18 anytime. That applies. If the child is 18 years or older, it would depend on whether the child is disabled and incapable of self-care. Bonding time, if both the mother and father of the child work at the same location, they get a total of 12 weeks for the purposes of bonding with the child only. Okay? They still, because if each of them don't use 12 weeks of FMLA to bond with the child, they will each have time left in their FMLA bank for other reasons too. Okay, chronic conditions. Just putting us back to where we were, right? We were talking about what is a serious health condition, and more specifically, the category of continuing treatment, okay? The third type are chronic serious health conditions. I spend a lot of my time talking about chronic serious health conditions. These are the conditions for which employees take that I kind of FMLA leave. What's that, guys? Intermittent FMLA leave, right? Where they call in unplanned at any given time and tell you they're not going to be at work. And then post on Facebook that they're actually in wherever, working their second job, going for a bike ride, out for drinks with friends, whatever it is, right? I'm cynical. Okay, so chronic conditions require treatment at least twice per year in order to be covered. I'm going to say that again. They require treatment at least twice per year. So if you look at the certification form for the employee's own serious health condition, you can see on the second page, which is page 4 of your handout, 1, 2, 3, 4, 5 lines down, 5 questions down, it says, will the patient need to have treatment visits at least twice per year due to the condition? Okay. Countless times I've talked to HR folks about some really thorny, intermittent FMLA situation, and I say, send me over the cert form, and they send me over the cert form, and guess what that is checked? No, it never should have been approved as a chronic condition in the first place. Okay, pay attention to that question carefully. If somebody is approved for a chronic condition, then they can take FMLA leave for flare-ups, which usually are unplanned. They can also take it for treatment, too. It's just that treatment we can often schedule around. It's the unplanned intermittent FMLA leave that drives us bananas, okay? Common examples these days, migraines, diabetes, any type of serious health condition, mental health condition. Boy, am I seeing an increase of that in the workplace. Asthma, epilepsy, stress. My supervisor stresses me out, so anytime my job performance goes downhill, I'm going to take FMLA leave. Okay? Next type of continuing treatment, permanent or long-term conditions for which treatment may not be effective. Okay, so there's one exception to that rule of everybody has to be getting treated, right? And that is if somebody has a condition for which there is no treatment, but it's permanent or long-term, the FMLA could apply. I think I've seen one of those in my 20-plus years of talking about the FMLA. Usually if an employee has a condition that's very serious and there's no treatment, they're either off continuously or unfortunately they're just not working anymore, right? It's like Alzheimer's, end-stage cancer, et cetera. So I don't spend a lot of time talking about that, but it's important for you to remember that it does exist. Here, just to summarize, employee has PTSD, is approved to take intermittent FMLA leave for it. Is that correct? As a chronic condition, he doesn't need to get treated every time he has a flare-up, which is usually the case, by the way, with chronic conditions. You don't need to go see a doctor every time you have a migraine, not necessarily, right? Can you count all of his absences under the FMLA? No, you can only count the absences for that condition under the FMLA. Yes, his obligation will be to either say FMLA or to specifically name his PTSD in order for it to fall under the FMLA. If he just says, not coming in today, then he's not giving us the notice he has to give us. Okay, next type of continuing treatment. Conditions that require treatment, but the person's not incapacitated so long as they get the treatment. These are employees that are missing work only for planned medical treatment, right? I need to miss work for chemo, but I am a badass champ and I am working through it and I come to work, otherwise I'm just missing work for chemo. I'm missing work for dialysis, etc., right? So I'm not incapacitated from working, I just have this condition and I need to miss work for my appointments. That falls under the FMLA. And then lastly, substance abuse. Okay, FMLA applies if an employee is getting treated for substance abuse, but that treatment has to be actually provided directly by a healthcare provider, right? Or on referral by a healthcare provider, right? So that's often inpatient or through Pine Rest or something like that. It is not generally AA meetings, right? Or NAAA meetings, et cetera. Okay, so now we know the reasons, right? With regard to taking FMLA leave to care for a parent, spouse, or child, then that begs the question of, well, what does that mean, right? Because we know it's FMLA, and nothing means what you think it's going to mean, right? So, a spouse includes anybody to whom you have been legally married, so long as the state in which you got married recognizes the marriage, even if you now live in a state that does not. Okay? That means same-sex marriage, right, now is broadly covered under the FMLA, but also, just so you know, it can apply to common law marriages. Even though Michigan doesn't recognize common law marriages, if an employee comes to you from a state like, say, Alabama, right, and is in a common law marriage, that spouse would be a spouse for the purposes of the FMLA. You are not supposed to read employees' minds and know that, right? However, I will tell you, for the purposes of benefits, etc., you usually know who employees' spouses are and what arguments they might have with regard to those with whom they live and have relationships with, right? Yeah, so the question is, what kind of documentation can we require? We can require confirmation that somebody's their spouse, yes. Common law marriages, that's a little bit more complicated because there are state laws that just say if you reside with somebody for X period of time, they are your common law spouse. Child. Okay, I have more slides on this, okay, but just to dive into it first, child is the most complicated definition of the three under the FMLA. And broadly speaking, a child is anyone to whom an employee is providing day-to-day care and financial support. Okay, there does not have to be a blood relationship, nor does there have to be a legal relationship. Okay, and usually that person has to be under the age of 18, but not always. There's even an exception to that. Okay, and I'm going to go into that. Parents. Parents do not include in-laws, although you'll hear me argue that this broad definition of child could be manipulated to apply to in-laws. I'm getting some nods from our advanced FMLA folks. They're like, yes, I knew it. There is that argument. But on paper, does not include in-laws, but it does include somebody standing in place of a parent. What do I mean by that? Well, let's take an example. Right, you have an employee who today comes to you and says, I am raising my granddaughter, right, because her mom is not in the picture, okay? Providing day-to-day care and financial support for this child. I need to take FMLA to care for her, right? That can apply. Let's say 25 years later, guess who works for you? That granddaughter. And she comes into you one day and says what? You guys are still in your job, I'm sorry to tell you, 25 years later. She comes in and says what to you? my grandma's not doing well, I need to take FMLA to care for her. That's what that means. That grandmother stood in place of a parent for her when she was young and raised her. Okay? Surprisingly, I don't get a lot of questions and concerns about that. I will tell you, right, that although the FMLA regs say we can ask for reasonable documentation to support that, that's a bit challenging, right, trying to figure out what that is given that these events occurred 25 years ago, right? Here's pictures of me and my grandma at my high school graduation. I'm not quite sure exactly what you would ask for. Okay, now I want to talk more about this idea that the FMLA defines child as under the age of 18, okay, unless the person falls into what's called an adult child. That means incapable of, there's two parts, right? Incapable of self-care and due to a disability. Okay. Now here's the really interesting part for those of you that deal with the ADA very much. For the purposes of determining whether an adult child has a mental or physical disability, we apply the definition of disability that the ADA applies. Okay? What do we know about how the ADA, how that's changed? What has happened over the last several years with regard to how the ADA defined a disability? Does anybody know? Has it gotten broader or narrower? Way broader, guys. The ADA's definition of disability used to be very narrow, and it has grown exponentially with the ADA Amendments Act and the EEOC's regulations that were passed after that. To have a disability now, basically somebody just has to have an impairment that makes it harder for them to do something important over several months maybe. It's hard to say for sure, right? The EEOC has said if somebody has a lifting restriction that lasts 3 or 4 months, we think they have a disability under the ADA. Okay, so bear that in mind, right? But that's okay because there's a second part here. So not only does the adult child have to have a disability, but they have to be incapable of self-care. Incapable of self-care means they need active assistance and supervision in 3 or more activities of daily living. These are examples: grooming, hygiene, bathing, dressing, eating, or instrumental activities of daily living. These really feel outdated to me. Using telephones, right? Who like to text? Is that what they're right? I don't. Taking public transportation, paying bills, right? Etc. So the adult child would not only have to have a disability, but need active assistance in 3 or more activities of daily living, right? So 10 years ago, we used to think of that in context of maybe a child who has had a disability for all or most of their life, right? Has Downs or something like that. And then they turn 18 and we think, okay, well that employee can still take FMLA leave to care for the child because they are now an adult child, right? Instead now we've turned our thinking to perfectly healthy adult children who may have an event that renders them disabled, right, for, again, a couple of months, several months. Now, this could apply to them too. So one example in the case law is an adult daughter was in a car accident, had 2 broken legs, hole in her lung, hole in her bladder, in the hospital for 30 days, off work for another 2 months. Parent requested FMLA leave to care for her, and the employer said, no, the FMLA only applies, your daughter's 40, The FMLA only applies if you're 18 years or older. Oops, the court did say that that is an adult child under the FMLA. Okay? Now bear in mind, this is also goes hand in hand with the idea that it doesn't have to be our biological child, right? It can be anybody for whom we're providing day-to-day care and financial assistance. Okay, so I'm gonna blow your mind for a minute, right? And think about how expansively that could be applied. That's why I say employees, if they understood all this, could take FMLA leave really to care for their in-laws, couldn't they? If their in-laws, for example, were living with them, right? Or that responsibility for caring for the in-law was falling on that employee. The in loco parentis exception would apply, and if the in-law is disabled and needs active assistance with 3 or more activities of daily living, boom, you get there. Okay, I'm not suggesting you go out and advertise this in your workplace, but what I want you to remember, keep that in mind, guys. That rule about a child being under the age of 18, be very careful there, right? And train your supervisors and leaders so that they understand there's a giant crater here of exceptions to that rule. Okay, so could adult child apply to a pregnant daughter? Well, what 2 questions are we going to ask, guys? Right? Number 1, is she what? Disabled. Remember, it's a 2-part question. Does she? Well, disabled is a legal definition under the ADA, right? So we need to look at exactly what's going on with her pregnancy and whether it might fall under the definition of disability as the ADA applies it. That's a very legal specific analysis. So, right, so possibly. Pregnancy itself is absolutely not a disability under the ADA. If pregnancy results in other health conditions, they can be, right? So she'd have to have a disability and she'd have to require activities of daily living, okay? Just one other example, try to keep folks out of trouble, right? When we talk about caring for an employee, that term is also very broad, right? It includes providing any emotional support, okay? Be careful about getting too picky about what care employees are actually providing. So here's one example. Employee was providing care for her daughter who had cancer and was getting treatment. Okay, took FMLA leave, continuous FMLA leave to provide care to her daughter. Okay, employer got upset because she learned that grandma was spending some of that time caring for the grandkids, who obviously lived in the same house. So she was providing this care in the daughter's home, grandkids were there, so as part of that care, she would drive the grandkids around, take them different places, etc., because the mom could not. Employer fired grandma, fired employee for doing that, right? Would say, I can see both sides of this story. I would hope that employer understood they were probably taking some risk in making that decision, right? And court said that is caring for the daughter, okay? Because it goes hand in hand. Caring for that daughter also included caring for the grandkids. Now again, I can argue that one both ways. Wouldn't say I'd be that surprised to see a judge or a jury reach a decision that maybe you didn't like because it doesn't like the facts. You guys know what I mean by that, right? We get to choose the facts on which we rely when we make employment decisions. If you're taking a position that has legal risks, right, it matters what facts you're picking. I think this judge didn't like that this employer fired the mom for caring for the daughter with cancer, etc. Point out is my math was bad on slide 12. just in case any of you were thinking that I should have been a mathematician instead of law school, that's not true. So if you look on slide 12 was the example of somebody who wasn't eligible for FMLA leave when her leave began, right? When I wrote that, I was like confusing my weeks and months. I don't know what I was thinking. But my point was that this employee would get 2 months, would take 2 months of leave that didn't fall under the FMLA at the front end, so that's about 8 weeks or so, and then get another 12 weeks potentially of FMLA leave after that. So on that last line when it says Beth could take a total of 14 weeks, that doesn't make any sense. That should be 20 weeks, not 14. All right, next question, question 6. We already talked about this, so I'm really not going to spend much time on it at all. Only to point out that this is something that did change in the last couple of years. So if there's confusion on your part about whether the FMLA applies to same-sex marriage, that's probably because the rule changed. The rule now is that celebration rule. So if the marriage occurred in any state that recognizes same-sex marriage, the FMLA recognizes it, period. So if they got married in any state that recognizes it, it's a marriage under the FMLA. That also applies to common law marriages. As I mentioned, we can require a marriage certificate. That's not always available, right? And bear in mind that sometimes for the purposes of benefits, those employees already have a marriage certificate on file to establish a marriage for the purposes of health care benefits, etc. Okay? Question 7. We sort of kept touching on this a little bit, so let's dive right into it, right? The question is, what notice does an employee have to give to me to take FMLA leave? How does that work? What do they have to say? How do I know when I'm on the hook or not on the hook, okay? And what I'll say first is when I think about the FMLA, I liken it to a game of ping pong or a game of tennis, something like that, right? Because we keep taking turns with the employee with regard to whose obligation it is to do something or provide something to each other, okay? So the game of tennis starts with an employee first telling us for the very first time that they need FMLA leave, okay? This is not a person who's already approved to take it. We don't know anything about it. So, sorry. To trigger that right to FMLA leave, that employee only has to tell us enough such that we should know that they might have a qualifying need for FMLA leave. This is frightening. Okay? This is frightening. They don't have to say FMLA. They don't have to specifically refer to FMLA. They don't have to come to us necessarily and get forms. They can just be telling us that they need to miss work for a reason that we are supposed to know falls under the FMLA. Okay? And when I say we, I mean not just all of you guys who have the benefit of being in this room today, but who else, guys? The supervisors, right? Which is why you guys probably here have heard it's really, really important for you guys to train your supervisors on the basics of the FMLA leave. Because if we have an employee who gives us this notice, right, they serve the ball to us, and we just stand there and watch it go by, we have a problem, right? They've just aced us, right? So we need to be able to recognize those qualifying needs of FMLA that we talked about, okay? So that's the notice they have to give us if they've not yet been approved. Now, they hit us the ball. Let's assume we didn't whiff, they didn't ace us, right? We did what we were supposed to do, which was to hit the ball back over the net by sending them certain forms that we're going to talk about, okay? Okay, and that game continues, and they get approved to take FMLA leave. If that leave is intermittent, meaning not continuous, okay, and they want to utilize it intermittently, they do have to be more specific in telling us that they're using FMLA leave at that point. We can require them to specifically say FMLA or specifically name the condition for which they're missing time. Okay, you guys following me? Okay, and that's very helpful because when we have an employee that's just calling in and saying, I'm not going to be at work today, we really, really need to know whether that's for a reason that falls under the FMLA or not. If it falls under the FMLA, then we can't count it under the attendance policy, right? We can't discipline them for that. And we take it out of their FMLA bank. On the other hand, if it's not FMLA, that may be counting against them under a no-fault attendance policy. If we screw that up and count an FMLA day under our attendance policy, and that ultimately leads to them getting discipline or discharge, they have a lawsuit based on one absence, if that's part of any adverse employment action. Okay, so those call-ins and what they're saying when they call in are critically, critically important. In addition, we can require folks taking intermittent FMLA to follow our usual call-in rules, right? So if you have to call in 2 hours before the start of a shift, et cetera. Now, this is the FMLA, so you know there's going to be an exception to that, right? Any guesses as to what the exception to that is? Unless what? Yes, unless they can't because of why? Because of their condition, right? I'm approved for FMLA because I'm on medication and my medication makes me sleep through my alarm, right? I can't make these things up, right? This is, okay? So, I also can't call in when my medication makes me sleep through my alarm. Right? Now we can talk with the employee about other potential solutions, right? So we know what's going on and can hold them to our call-in rules, etc. Okay? With regard to that first initial request for FMLA leave before they're approved, if their need is foreseeable, we can require them to give us at least 30 days notice. Surgery, bonding time for the birth of a child, etc. If it's unforeseeable, we can only require what's practicable. They're supposed to tell us as soon as they can that they need FMLA for that reason. Your notice forms are the first and the last forms, okay? So the first notice form is a notice of eligibility and rights and responsibilities. When the employee serves the ball to us, that is the form we are supposed to send them within 5 business days. Okay, the notice of eligibility and rights and responsibilities. As you can see, that's where we tell them whether or not they're eligible. That's where we tell them if they're going to have to provide medical certification, if they're going to have to supplement paid leave, etc. Okay, if they're a key employee. Okay, if we are going to require medical certification to go along with it, we check the box or check the line at the bottom of that first page. And we enclose one of the 4 certification forms. 99.9% of the time, it's going to be one of those first 2. Certification for the employee's own serious health condition or certification to care for a family member. Okay? We have to do all that in order to return the ball to the employee. One other note, if this time is just for bonding time, to bond with a newly born or newly adopted child, pop quiz, guys. Are we going to require a medical certification? No. For those who said no, why not? It's out, yeah, there's no medical, there doesn't even have to be a medical issue, right? We get to bond with a newly born or newly adopted child if everybody's perfectly healthy. So why would a doctor have to answer those questions? All they have to do is show us that that child exists, newly born or newly adopted. Since we're giving pop quizzes, when can that bonding time be taken? Anyone know? Any time in the first year of the newly born child's life or after the adoption, okay? If a mom has given birth, typically that ends up being taken right after the birth, or after she exhausts her disability leave, and then she takes bonding time. The second parent may be taking that time 6 months later, right? Every year, right around November 1st, what's November 1st?
Hunting season.
Hunting season. I get to work and I think, oh, I can't wait for my first FMLA bonding time. A dad is taking leave phone call today. Because it happens predictably every year. My bonding time is starting on the hunting opener. Then we get to the medical certification process, right? So the employees served the ball to us. We sent them back the notice of eligibility, rights, and responsibilities. And if it involves a serious health condition, the medical certification form they have to complete. For the game of tennis to continue, they have to get that medical certification back to us, right? Within how many days, guys? 15 calendar days. From when? From when? When we give it to them. And by give it to them, I mean it's in their hands. This creates a conundrum when we put it in the US mail, right? It is not from the time we put it in the mailbox, it's from when they actually receive it, okay? I know. Just when we thought we were doing everything right. If you're sending in the US mail, just add a couple of days, like a buffer for them to get it. Although, man, the US mail gets slower every year. So I live in Kalamazoo. Do you know that for me to send a letter across the street, it comes all the way up to Grand Rapids and back? That's a true story, right? So I'm trying to get clients more in line with electronic communications with employees. Emailing forms is perfectly fine. There's nothing in the FMLA regs that says you can't, right? So that's a great way to do this, okay? These medical certification forms, I'm not gonna painstakingly go through them with you, but there's a handful of slides here that point out these sections on the forms that link directly to those definitions of serious health condition. You need answers to all of these questions in order for you guys to know whether somebody has inpatient treatment or continuing treatment. I promise you, okay? So when the condition started, how long it's gonna last, were they admitted for an overnight stay, right? And if you were wondering before why that question is asked on the forms, now you know, right? Because inpatient is covered, etc. In the second section of the form, if an employee has a chronic serious health condition, it makes the healthcare provider estimate the frequency and duration of flare-ups, right? Healthcare providers hate that section of the FMLA form, right? Why? Because they don't, I mean, in fairness to them, right? They don't know, okay? Nonetheless, it's really, really important for us to have that estimate, right? It's important for us to understand what to plan for and also to understand if somebody might be misusing FMLA. Okay, so you got to get that section completed. If it's blank, I would encourage you all to make clear to the employee or the healthcare provider right? If the healthcare provider is pushing back. This is just an estimate. This is not a promise, okay? And you guys are going to hear me say this again. We cannot terminate somebody's employment or automatically deny FMLA leave the minute their use exceeds that estimate. All that estimate means is they are outside of what this doctor said we should expect. So we need to figure out what to do about that. Okay? The employee has 15 days from the date they get it to return the form. Okay? Sometimes, often, maybe even almost always, right? We get the form back, but what? It's deficient in some way, right? It's either not complete, there are sections that aren't completed, or you can't read the handwriting, or you read through it and you think, well, this doesn't make any sense. On this part of the form, the doctor says this person's not incapacitated from doing their job, but then over here, it says she needs to be off for 8 weeks. I don't understand, right? When that occurs, we need to give them 7 more days to fix it and explain the deficiencies to them in writing. So the question is, they will not get the form back to you for whatever reason, right? You give them the 15 days, you're really nice, you say, here's some more time, they still don't get it back, here's some more time, can we deny it? And the answer is yes, unless, because remember, it's the FMLA, just always assume there's an unless. Unless the employee can demonstrate that it wasn't their fault. Their failure to get the form back to you was something that was out of their control, right? So usually what I do is, even after the first time, if you give them more time, I would say to them, preferably in writing, please let us know if there's a reason for this delay that is out of your control, not your fault, so that we can be aware of it, right? So that we're not guessing. And then that puts the burden on them to tell us that. Otherwise, this is just an employee who is being difficult, doesn't want to get the form back, and or doesn't want to pay the $25 for the provider to complete it, and is wondering if they really have to. Okay? Now, if the form is confusing, or the handwriting on the form looks strangely like the employee's own handwriting, right? That's what I would call authentication or clarification. We have 2 options. We can go through that first route that I just mentioned. We can give it back to the employee and say you have 7 more days, get it fixed. Or an HR person could contact the healthcare provider directly for the purposes of clarification or authentication, okay? And that's cool, that's great. What I would warn you of, though, is if you end up getting information from a healthcare provider on which you're going to rely to make a decision to, for example, deny FMLA, we really, in a perfect world, would like to get that in writing from the provider somehow, or confirm it in writing with the provider somehow, right? I just had a DOL investigation for an employer for a client, and they went through this process, and I'll not go through all the facts because it's really convoluted, but the bottom line is this involved a female employee who had given birth and had said initially she was going to be back after 6 weeks, right? And she just didn't come back. Okay, and they're trying to figure out why and get a new cert form, okay? She was telling them along the way that it was because of her own serious health condition, not for bonding time. The reason she was making that distinction is if she wanted to take the bonding time, that employer required at least the 30 days notice ahead of time. So she wouldn't have provided the notice and it was going to get denied, okay? She turns in a cert form that made no sense. Employer reaches out to the healthcare provider tells the employer verbally it's for bonding time, she's fine. but they have zero documentation of that. It's based only on a telephone conversation with the employee's own healthcare provider, okay? She then files a complaint with the Department of Labor. We have an investigation. It ended up being fine in front of the DOL, but I still have concerns that if we have to litigate that case, our entire case is dependent on the testimony of her own healthcare provider and whether they are going to corroborate our account, right? As a lawyer, that makes me really uncomfortable. You guys see what I'm saying, okay? So do whatever you can in some way. Employers don't like it when they find out they've done something to get their patients fired. All right, if we get a certification form back and we have reason to doubt the validity of the need for leave, there is a second and third opinion process available. I don't really want to spend a lot of time talking about it other than to say it is time-consuming, expensive, and therefore we need to choose carefully when we would want to go down that path of a second and third opinion. I've done it plenty of times and had it work very well plenty of times, but you guys aren't going to want to spend your time doing that every time somebody requests FMLA. Sure. Oh, great question. The question is, who qualifies as a healthcare provider? So the Department of Labor has a really long definition of who a healthcare provider is, and it lists all sorts of things. And then at the end of it, there's a catch-all that says, and anyone else that for whom your healthcare plan will pay for their services. So usually, right, that's the first question I ask. Well, is your healthcare plan going to cover that treatment visit with the chiropractor? If yes, that person is a healthcare provider under the FMLA, okay? Now, the second and third opinion process can be useful in the context, by the way, of getting them to a different healthcare provider. That is one way I use that, right? So for example, I've had lots of employees with very serious, seemingly serious mental health concerns who are being seen only by their own family doc, right, or primary health care provider. We may use a second opinion doc to get them to a specialist because we think if they get better treatment, right, to sort of send them on that path, then they're going to be more successful at work. Does that make sense to everybody? So that's one way that using the second and third opinion process has not necessarily resulted in an employee being denied FMLA leave, but has put everyone in a better place. Okay, if we do second or third opinions, we really, really, really need to take the time to make sure it's done well and done effectively, right? And so we want to talk to the provider. I'll often use sort of a customized cert form. Be careful doing that because the FMLA regs do specifically say what can be in a cert form and what can't, but sort of tailored to that individual, asking the questions that we really want to know instead of all those questions that some of which may really not be relevant at all, like is it pregnancy and are they inpatient, for example, right? If an employee doesn't engage in that second opinion process, then we can deny the leave. Good news, I'm not going to go through this crazy flow chart, right? This is just something I dreamed up in the middle of the night, one night. This is how I think, this is how my brain works. So if this is also how your brain works, you may find this helpful in working through the FMLA certification process. If this is not how your brain works, then you can ignore this slide. The question is, who pays for the second opinion? We do. And if the second opinion goes our way, then we have to get a third opinion and we pay for that too. So for the second opinion, we get to pick the healthcare provider, but it can't be with somebody with whom we regularly contract, meaning it can't be an OC Health doctor. And for my poor hospital clients, right, or medical facility clients, right? It can't be anybody that's under contract with them, which creates all sorts of fun issues in a small town, right? For the third opinion, then the employer and the employee are supposed to decide jointly what healthcare provider to use, which makes for an interesting process. We usually suggest like a list to the employee and see if they'll be willing to pick one off the list or something, some compromise like that. Okay, so question 10, now that I've got this certification, okay, let's first go back to the game of tennis, right? So the employee hits the ball back to us by returning the certification to us. Let's just assume it's timely and complete and authentic, and it doesn't require clarification. We have what we need to make a decision about their FMLA leave, okay? The last thing we do is provide them the second notice, which is called the designation notice. That's the last page of your packet. This notice is really important and often forgotten because we've been so far in the weeds, right, with that medical certification process. We finally complete it, we get what we need, we make a decision, and then we forgot to send out the designation notice. Okay? The designation notice is really important because that's the notice telling them that this is counting against their FMLA entitlement. Arguably, if we forget to send that to them, we can't count it against their 12 weeks. We have to send them that notice, and you guys will see that we have to send it whether it's approved or whether what? It's denied. Okay, so you can't just tell them. You got to send them this notice and have it documented. By the way, one other thing, I'm sure you guys are doing this, right? But don't forget, when we send these notices to employees, you need a copy of it too, right? I can't tell you how many times I've been through an FMLA audit or talked to an employer about an FMLA situation, and I say, well, where are the forms you sent? And they say, what? Well, I don't know, I sent them. The employee has them. Okay, you gotta make a copy. Make a copy for your own records too. Okay, so when can we get a renewed cert? Okay, bear with me here because this gets in the weeds of the FMLA a little bit. Okay, there's two types of renewed certifications under the FMLA. They are called recertifications and new certifications. Okay, those are the terms I'm going to use. Okay, a recertification is like just a check-in. Okay, let's take an example. I tell you that I have a chronic serious health condition, let's take migraine headaches, and I need FMLA leave, and we go through that whole process. My medical certification is probably going to say the duration of my condition is what? Lifetime, forever, right? Okay. My employer, right, can approve that for 1 year. Okay? 1 year. My employer doesn't have to approve it for my entire life. Right? So that certification gets approved for 1 year, and that's beginning from the first time I took time off for those migraines. That falls under the FMLA. Okay? For 1 year. So I'm now certified for 1 year. During that year, my employer can get recertifications under certain conditions. Okay? Recertifications are fine, but my employer can't check my eligibility, nor can my employer get a second or third opinion. And it usually involves the person just going back to their doc, bringing the cert form in again, and what does the doc do? Fills it out again, person pays $25 and brings it back to you. It's a hoop to jump through. Sometimes it's effective. I can make an employee get a recertification like that during an FMLA leave every 6 months, just because I want to. I can make them do it if circumstances have changed significantly. For example, my cert says I should be expected to have a migraine headache twice a month for 1 to 2 days each time, and I'm now calling in every week. Okay? Or the third bullet point there is the liar, liar, pants on fire example, right? One thing we can do if we think somebody's misusing FMLA is require a recert. That's not a real, I mean, I'll be honest, it's not a real effective way to handle potential misuse, but we certainly can get a recert. Okay? Those are recertifications. Also, at the end of my year, with the first absence, after that leave year ends, my employer can make me get a new certification. With a new certification, my employer gets to determine whether I'm still eligible. It's a new FMLA leave. Sometimes you may have employees who take a lot of intermittent FMLA leave, and they get through that year, and guess what? They haven't worked 1,250 hours. So you can tell them you are no longer eligible to take FMLA leave. You have to re-meet these eligibility requirements until you can begin taking it again. That can be really helpful with regard to thorny intermittent FMLA leave issues. And then also with a new cert, we've got that second and third opinion process open to us again. Under the ADA, it can be a reasonable accommodation to allow somebody to take continuous leave. And I say can be because the ADA lets us think about undue hardship and what's reasonable, right? Okay? However, under the ADA, it's one of my favorite things about the ADA. Employees still have to be qualified to perform their essential job functions even under the ADA. And this is really awesome. Courts have held again and again that regular and predictable attendance is an essential job function. So unless we've got a really weird job for which it doesn't actually matter whether somebody comes to work or not, your person, right? To which I would say, why do you pay them, right? Then the answer to your question is no. No. If somebody's no longer eligible for FMLA leave or they've exhausted all of their FMLA leave, we don't necessarily have to let them continue to take intermittent leave under the ADA. At that point, though, what would we do under the ADA? Would we sit down with them and explain the situation, number one? Seems like a good idea. That's what we do, right? Yes. You're like, yes. She's the lawyer. If she says yes, that's probably what we should do, right? Yes, we would tell them, and we would explain your job, regular and predictable attendance is an essential job function, etc. And then what are we going to ask them, guys? What's the $1 million question? Yes! Mary? Mary wins do we have prizes? A cinnamon roll? Mary wins a cinnamon roll, right? What can we do to help you be successful in having regular and predictable attendance now that you don't have FMLA at your disposal? What box are we checking there when we ask that question, guys? Reasonable accommodation. And you'd be surprised, actually, and boy, am I going to go down a rabbit hole here, but you'd be surprised at the number of times we get an answer and we think, well, crap, I wish we had known that all along. Yes, if I had this schedule. Yes, if I could sit for 10 minutes Twice a day. Yes, if I could blah, 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 blah. Okay? So then, just one more point about that. To put this seed in your head, we can use that ADA reasonable accommodation process even when somebody is taking intermittent FMLA. Right? The ADA would allow us to sit down with them and say, hey, you're approved for intermittent FMLA, that's fine. That's your right. That's approved. It's not being counted against you. But what we'd like to talk to you about is there anything we could do so that you could have more regular and predictable attendance? Right? That can be really effective. Yeah. We don't research because somebody has run out of FMLA. We research for one of the reasons on the research slide, or because it's a new leave, or because their year is up. Right. I think the question is right. If we are an employer that's going to require recertification after 6 months, do we have to do that for everybody and put it in a policy? No, absolutely not. We can take that case by case. I mean, obviously we can't discriminate against folks. We're not going to only ask the men, right? Or et cetera. But if we've got a legitimate reason to do it, then you can do it case by case. Yeah, so whether or not you are a successor under the FMLA, of course, is a legal analysis, right? But assuming that you are a successor, then all of that carries over. Correct. You basically step into the shoes of that former employer. Okay. Next question. What if somebody's been off work, but oops, I forgot to designate it, right? Let's take an example so that we don't have to use any real life examples in this room, right? Because I know it's happened. Happens all the time. Sally's a nurse. She hurts her back lifting a patient. Workers' comp claim is filed, and the HR department quickly runs down that workers' comp path, right? We don't think about the FMLA. We think, oh, it's workers' comp. She's on, I hear this all the time, quote unquote, workers' comp leave. There's no such thing, by the way. Workers' comp is money, it's not leave, okay? 16 weeks later, the IME says Sally's at maximum medical capacity, which is a really fancy way of saying she's probably not ever coming back to work, okay? The director calls you guys and says, okay, am I good to fill Sally's position? What's the problem? She was never noticed of her FMLA rights and was never told that we were counting it against her FMLA leave. So she arguably has what still, guys? 12 stinking weeks of FMLA leave. But you really, really, really don't want to tell the director that, right? So you call your lawyer and say, help me, please. Get these phone calls weekly, right? The good news is we can, if we make that mistake, we forget the designation notice, we can retroactively designate the FMLA so long as it wouldn't harm Sally in any way. And by that I mean Sally doesn't have an argument that had we sent her the notice at the front end, she would have done something differently. Right? Now, the beautiful part about the example I gave you is Sally probably said all throughout the workers' comp process, what? I can't work. We've got medical information saying Sally can't work, right? So in that case, really not a problem to go back and retroactively designate the time. There's a process that we want to follow, though, right? I've got a cover letter with a designation notice, et cetera, explaining to the employee what's happening and what we're doing. The one time you really want to be careful, though, is if an employee is taking time off not for their own serious health condition, but to care for a parent, spouse, or child. Because in that circumstance, it would be much easier for them to credibly say, well, if I had known you were counting this against my FMLA, I would have found different care for my mom. right? If I had known you were going to say I couldn't have my knee replacement then, right, in 6 months, then I would have done things differently. So we need to be careful in that circumstance. Okay, just quickly, so what does it mean when an employee is using FMLA, right? Well, they get their same position, meaning we can't discipline them for taking it, we can't count any time against them under our attendance policy, we can't count it we can't give them points for it, and we also can't count it against their performance review either, right? So be careful there. There's lots of cases that talk about employers who didn't count it under an attendance policy, but then an employee got a review because they didn't complete work that they were supposed to complete during an FMLA leave, and they got dinged for it. Also, they get their same health care coverage while they're on leave. They are supposed to be paying their usual cost of the premium during FMLA leave. That can become complicated as to whether and how they pay it, and if they don't pay it, what we're going to do about it. That varies widely from one employer to the next, to be honest. Okay, so let's continue this conversation about non-FMLA leave. Okay, what if somebody can't come back after they've exhausted their 12 weeks of FMLA leave? Or we could also say, what if somebody's not eligible for FMLA leave and they have a need to miss work for their own health concern? Okay, anybody had that? Right. About 5 years or so ago, the EEOC started very aggressively filing lawsuits and taking very strong positions in this regard. And that has only continued, okay? So the 10,000-foot view, the overall concept is that time off work can be an accommodation under the ADA, okay? So, but let's take a step back and let's talk about what that means for a minute, right? So accommodations under the ADA are things that we do for an employee so that they can perform their job. Everybody following me? Okay. And that concept applies to leave as well. So the idea is if somebody needs leave in order to come back and do their job, then we need to engage with them about that opportunity. Okay? What does that also mean, guys? That if somebody needs leave and we have no idea when or if they are ever coming back to their job, is that likely going to be something we have to do under the ADA? No. Okay? So the framework for how we consider and address leave under the ADA is much different than how we consider and address it under the FMLA. Right? Under the FMLA, it's all about what's their condition? And does it fall under the FMLA? And if it does, we have no choice, we have to give it. Under the ADA, the analysis is instead, number one, what does their job require? Number two, is there anything we could do to keep them at work? And number three, if not, do they have a date of return? And number four, would giving them that leave to that date of return be an undue hardship on us? Okay, so you can see why, for example, you wouldn't want to give them a FMLA certification form and say, just fill this thing out again and we'll use it for non-FMLA leave, which I see lots of employers doing. They just cross out FMLA at the top and say, here's another medical form, fill it out. Well, that doesn't ask or answer any of the questions we need answered, right? Okay. So, of course, this is only with regard to the employee's own serious health condition. I'm going to skip over all the scary EEOC stuff and everything they're saying. This analysis is made on an individual basis, okay? Meaning it all depends on that person's job, whether they have a date of return, and whether we might be able to say that it would be an undue hardship to give them that time off work. Another way of putting it is, that makes it really, really hard to have a leave policy that says nobody ever gets more than 6 months, right? And the EEOC says that's unlawful because you're supposed to make these decisions and talk about these things based on that employee and based on an individualized consideration, okay? So the EEOC continues to bring these class action lawsuits against employers that have leave policies that have established times at which employment is automatically terminated. Let me be clear, when I first started doing what I was doing 20 years ago, I think about every non-FMLA leave policy I saw had that. Said, we will give up to X amount of time, and if you don't come back, your employment will end. Okay? This is a 180, right? And I have lots and lots of clients for whom the HR folks completely understand this concept and understand how to apply it, but they continue to struggle with leadership. Supervisors and managers not understanding why in the world we have to continue to give folks off and or not post their position when they've exhausted their FMLA leave. Okay, I'm guessing you guys have the same struggle. For this process, obviously medical documentation is required and highly, highly recommended. Over and over again, when I see an employer that doesn't have a process in place, like FMLA leave, doesn't have a form that asks the right questions, they're going from one medical note to the next, right? And what happens then, guys? It keeps getting what? Extended. And these medical notes that says Sarah is off until and gives a date, okay, those are usually telling me a date that's based not on when I might be able to come back, right? It's based on when I'm what? When I'm going to my doctor the next, right? So you don't have any information that's helpful to you to determine what in the world you're supposed to do or have to do under the ADA, if we're doing that, okay? Okay, so as we think about updating our leave policies to account for non-FMLA leave, right? We want to make sure they don't automatically terminate employment. We want to make sure we have a process in place in which we're communicating with the employee and have an HR person that's evaluating the situation. At the same time, right, we're balancing these things. We can't have an automatic cutoff, but we also don't have to let employees be off indefinitely either. We've got this ability to draw the line if we have the right information to rely on to do that, okay? By the way, please make sure the 100% healed language is out of any leave policy you have. Again, I continue to see that too, right? We don't return anybody to work with restrictions, for example. Everyone has to be 100% healed in order to come back to work. Why are those problematic, guys? What's that code for? You can't work here if you have a disability, right? I mean, thank God we don't all have to be 100% at work all the time, right? I often think that, good Lord, I'm glad I don't work there 100% healed. I haven't been 100% healed since I was 11. Okay? So we're going to be taking these cases on a case-by-case basis. You really want to have a leave process in place, and you want to have a form or documentation that asks those right answers under the ADA in order to get that done. I promise you, if you have those things, you're going to be able to get your hands around and manage this and not have those employees who are off and off and off and off, and you don't know what to do about it. So the question is, what if somebody has more than one reason for FMLA? Do they have separate FMLA, 12 weeks of FMLA for each of those, or combined? I have great news for you. Everybody has 12 weeks of FMLA, and you can take it for one reason or you can take it for 27. It really doesn't matter. You only have 12. Okay? I've seen employees with 7 different certifications. Right. With regard to non-FMLA leave, at what point do those extensions really become indefinite? Is that what you're asking? Yeah. When does it become unreasonable?
When am I safe to say we can't do this?
Right. Okay. So it's sort of a two-part answer. Number one, you can have a situation in which a doctor just keeps giving you definite dates of return, but then when that date comes, what? Oh, I guess I was wrong, right? No, really, they're coming back July 1st. Ah, wrong again, right? After that happens once, I have clients send a letter and the doctor wants to extend it again and says there's a definite date of return again. I send a letter saying, you have to tell us why you're sure this time it's definite. And they usually back off and say, yeah, I don't really know. Secondarily, don't forget, we can always take the position that giving somebody non-FMLA leave is an undue hardship if we've got grounds to show that. And that's a different legal analysis and sort of part of the process, right? Undue hardship basically means it would substantially disrupt our operations to continue to allow this person to be off work and or hold their position for them during that time, right? Like you guys during open enrollment, you can forget about it, right? You're not, right? No laughs about that. Everybody was going to take non-FMLA leave during. Okay, one more question, then we're going to move on. Yep. Are we required to continue health benefits, right, is what you're asking for somebody on non-FMLA? We need to follow our health plan with regard to that. Your health plan will often say you can't continue, these benefits will not continue if somebody's been off for more than 12 weeks. That's fine. You put them on COBRA then, right? And then they got to pay the cost of it. Does that make sense? If your health plan doesn't say anything about it, then it's about undue hardship. So I spend a lot more time talking about suspected misuse of FMLA than I ever have, and every year it's more and more and more and more. Any guesses as to why? Yeah, right. It used to be that somebody would call in FMLA or take an FMLA leave, and there might be rumors about Sarah really going on vacation or Sarah working at another job, or every once in a while somebody got caught on the big camera at the baseball game, right? Really bad luck. Or there was a picture in the newspaper of them in the parade, just bad luck, right? Well, now everybody feels compelled to announce where they are and what they're doing at all hours of all days, thinking that although they're announcing it to the world, somehow their friends, right? I quote friends, right? At work are not going to tell their employer what they're really doing. So if you have not already, you will get a leader come to your office and hand you some printout of a tweet or a Facebook post or something of one of your employees who is on FMLA leave and say, here's what they're doing, what can we do about it? Okay? I laugh, I think. I don't know what private investigators do anymore, right? We used to hire private investigators to follow folks on FMLA leave around to see if they were lying to us or not. We don't really need them anymore. They do all that work for us. With regard to FMLA use, it really is not nearly as complicated as you think it is. Okay? Number one, this is an issue of honesty or dishonesty. Okay? If we think somebody is lying to us or has been dishonest to us, then we need to investigate it and reach a conclusion. Okay? And courts across the board have said, if you've got a reasonable basis to believe somebody lied to you, then that is not covered under the FMLA, and you can follow your usual discipline with regard to dishonesty. If in your organization that's a terminable offense, fine. If it's not, then we would follow whatever process is appropriate. Okay? Another way of putting it is, just because it's FMLA doesn't mean we have to run away afraid. Okay? So, what does that mean? When I get that phone call from you guys who say, okay, here I go, I didn't want it, you promised it would happen though, here's the Facebook post of Sarah up north on vacation with her family when she was supposed to be on FMLA leave. Okay? We're going to conduct an investigation. Where are we going to start? The first thing I'm going to tell you to do is pull out that cert form. Right? That cert form, one of the questions on the cert form is, what essential job functions can't Sarah do? I want to know what it is Sarah's not supposed to be doing when she's on FMLA leave. That's my first thing. Right? That matters tremendously. If it says I can't work my production job because I can't lift more than 10 pounds when my back flares up, right? And I post a picture of myself rock climbing, that matters. It also matters if I'm a nurse and it says Sarah has bipolar and I can't engage in appropriate interactions with patients when I'm having a flare-up, yet I go to the beach. You guys see the difference? So the first thing is we gotta get our arms around what's the reason for the leave, what does the cert say, etc. What do we know about it? Are there any other opportunities to get more information? Are there other witnesses, etc.? What do we know? We gather all of the information, okay, including what's on the cert form. Then what would every good investigation include, guys? A meeting with who? Yes. We're going to get the employee's side of the story, right? Okay. We're going to get the employee's side of the story. This is an opportunity for you to see whether the employee is going to tell you the truth during the investigation. Okay? Because if the employee lies to you during the investigation, your lives just became a lot easier. You guys see what I'm saying? Okay? About half the time when I've had these issues, when we sit down and talk to the employee, they look at the HR person in the face and tell a lie that we know for a fact is a lie. What did you do when you called in on Monday with your migraine headache? I never left my house. I was in a dark room all day long. Okay? Then how do you explain this? Right? They are caught in a lie. And then we make an employment decision based on that lie, and we no longer worry about whether it was appropriate for Sarah to go to the beach when she had bipolar because she just lied to us during our investigation. That's called being strategic about this, right? Otherwise, if they tell you the truth, then we're going to continue to gather the information, and we're going to have to make a decision about whether we have a solid basis to conclude that they lied to us, otherwise known as an honest belief that they violated our rules. If we can articulate that honest belief, then it will be defensible in court, even if we're wrong. We only have to honestly believe it, okay? That means we need to have more than rumor, and we need to have engaged in an investigation in good faith, including talking to that employee, getting their side of the story, and if it turns out we don't believe them, then we need to be able to explain why, articulate it. Okay, when we have those things, we are in a very, very strong position to then take employment action and defend it if we need to, okay? The amount of legal risk that you're going to want to take is often dependent upon how much suspected FMLA misuse you have in your facility. If that's a big problem, right, then we may be looking for opportunities to catch someone doing it, because that often is a proactive way to stop others from misusing FMLA leave too. Okay? Other, beyond investigation and taking action, other ways, sort of softer ways of handling misuse of FMLA is some employers require a written leave request for all absences, including intermittent FMLA leave absences, and they have a certification on them saying, I promise I'm using this for legitimate reasons, et cetera. We can do that, okay? Obviously, we enforce our call-in rules, that recertification process, check-in procedures, et cetera. Our FMLA policy should have good rules about how we expect employees to be using their time when they're on FMLA leave. For example, we can prohibit any outside employment just because. So we can tell an employee, you are not allowed to go work anywhere else while you're on FMLA leave. Even if it's true, you can't do your job for us, but you could do a job somewhere else. You're still not allowed to do it if we want to do that. Okay? We can also include rules saying you're not supposed to go on vacation, out of town, et cetera, unless you have permission, for example. There's sort of a famous case on that in which an employer did exactly that, and the court upheld it. Okay? Again, the level, the type of approach you have is going to depend a little bit on your workplace and the use of FMLA in your workplace. So, last question. How does the FMLA coordinate with who knows what the MPMLA is? Yes, this is kind of mean of me to save this for last, isn't it? I'm going to make you really think all the way to the end, right? How does it coordinate with the new Michigan Paid Medical Leave Act, right? So, if the FMLA applies to you, guess what, guys? The MPMLA also applies to you. The MPMLA tells you you have to give folks at least 40 hours of paid time per year through some sort of paid time benefit. Could be something they were already getting. Could be PTO, could be vacation, could be any way you want to provide it, okay? And employees get to use that time, they get paid for it, and it is also forgiven under a no-fault attendance policy. So we also can't discipline employees for taking it, okay? So it's like FMLA leave. So here's the thing about the Michigan law. It's new, we have no regulations, and we have no case law. We only have the words in the law. Seriously. So we know a lot more about the FMLA because we've got these other layers of information to color it, right? So the FMLA regs say it can apply to common law because we've got the regs. The Michigan law simply says spouse. That's all we have. Familiar with that. What I want to talk about are the available uses, okay? The uses under the Michigan paid law are much broader than the FMLA. Okay? Employees can take this for any illness, injury, or health condition for themselves or a family member. That's broader than how the FMLA defines serious health condition, right? This is anytime somebody's sick. Anytime. All they have to do is call in and say, I'm sick, and the Michigan law applies. Okay? So, if we know somebody's taking FMLA leave for a serious health condition, there is always going to be overlap with the Michigan law. Not vice versa, right? But if somebody's taking FMLA leave, let's say for their own serious health condition or to care for a family member under the FMLA, this time off under the Michigan law will apply too. There's only one exception to that, and that's bonding time. Bonding with the newly born or newly adopted child. Okay? Actually, there's more than one. The military leave stuff also. Okay? But think about that. So that means that we've got an opportunity here to coordinate FMLA and MPMLA. If somebody's taking FMLA leave, we can tell them, you also have to utilize your 40 hours of paid time under the Michigan law. The FMLA allows us to do it, as does the Michigan law. Why do we want to do that? Why would you want to? Exactly. So that, for example, I still only have 12 weeks of intermittent FMLA, not 12 weeks of intermittent FMLA plus 40 hours of attendance policy protected time off under the Michigan law. I'm seeing nods. They're either like, I'm gonna nod so I can leave, or they got it, okay? All right, I'll skip through that. So the point of this answer was this, right? Now, don't forget, in our notice of eligibility and rights and responsibilities, we have to check a line telling employees if they're going to be required to use paid time. So if you want to coordinate those two, don't forget, you got to check that right line. It's the FMLA, right? You got to check the right line, you got to check the right box, et cetera, to make sure you do it right. But that's an opportunity to reduce that attendance protected time off. Yeah. Thank you.